Hello, today we're going to be having a look at breach in the area of tort law negligence, and you will be able to find this whiteboard summary, a close-up of it on my websites to aid you while watching this video. So let us begin with the central question: what is breach? Well, it's the second thing we have to establish after we've established the duty of care, and basically the question is whether the defendant was in fact negligent. The question is not should we be holding this defendant liable in the first place, but was this defendant, now that we've established that he can be held liable, was he in fact negligent? That is the central question we're having a look at. So, what is used to assess breach? Well, the objective standard of care test is used, and this is basically the test of what would a reasonable man do. And the well-known way of explaining this is they say, what would the man in the Clapham omnibus do? And that arises from the Hall and Brooklands Auto Racing Club case in 1933. And how do we explain this test? How does it work? Well, it's an objective test. We don't care about personal characteristics. So, for example, in the Nettleship and Western case, 1971, a learner driver had an accident, but she was still held liable because she was found negligent as to what a competent normal driver would do, even though she was a learner, because it's an objective test. What would a reasonable driver do? And why do we have such a high standard we require of people? Well, Denning in Nettleship, he specifies that this has got a lot to do with the spread of liability insurance, and it's basically policy reasons. He says we are beginning to move away from the concept of no liability without fault and beginning to move towards to apply the test on whom should the risk fall on. And so even though morally the learner driver is not at fault, but legally she is liable because she's insured, and that is the best place for the risk to fall. Now, what are the factors that the courts take into account when they're trying to work out whether, in fact, this person has been negligent? Well, there's 5 factors to take into account. The first is foreseeability. This is the idea that we're not looking in hindsight, but at the time. So that means that any later developments, later scientific developments, cannot affect the defendant's behavior. And the case for this is in Roe and Minister of Health, 1954. The second factor is the magnitude of risk that is involved. So there's 2 ways of looking at this. First is what is the likelihood of the harm actually occurring? And here we can compare 2 cricket cases. In Miller and Jackson, it was to do a cricket ground where the neighbours were victims of balls thrown. And in Bolton and Stone, it was the remote possibility of injury occurring. Somebody had been injured by a ball, but it was found that there was more likelihood in Miller and Jackson, and hence why it played, an even more important role in showing that breach had occurred. Whereas in Bolton and Stone, it was more to do with the fact that there wasn't sufficient probability of this harm occurring. Then you also have the severity of the harm. That is also related to the magnitude of risk. So in Paris and Stephanie Borough Council, it's the idea that a one-eyed man, if he gets hurt while doing work, he's completely blind. That is really severe. So you would expect goggles to be given to him, even though in the workplace industry it was set out that goggles were not required. The third factor they take into account is the practicality of proportions. So in Latimer and AEC 1953, basically the claimant slipped, and it was to do with floods that had come in. But the defendant couldn't be held liable because what the claimant was suggesting is that a reasonable, prudent business owner would have closed the factory down. And actually, this is not practical. The defendant had put sawdust, the defendant had put warning signs, and they had kept the floor to an efficient level. So, you have to look at the practicality of what you are expecting people to do. The fourth factor is the potential utility of the defendant's conduct. So in Watt and Hertfordshire City Council, it was to do with a fireman. And what Lord Denning stressed is you have to balance the risk of what can occur in the activities that the defendant was doing against the end to be achieved, and the fireman's end was to rescue people from emergency fire situations. And the fifth factor to consider was common practice. And this was made explicitly clear in the case of Bolethio, City and Hackney, HA 1977, where basically they refer to the Bolam test we'll talk about in the next video. And they said you need to look at what a responsible body of medical men or people in that field are saying about what happened, and only in rare cases would it be, the courts would reject this expert view. And it's the same thing in Sutcliffe and BMI Healthcare 2007. The judge had been entitled to rely on the opinion evidence of anaesthetist expert witness in finding there was no link between the omission that the case concerned and the injury. So in my next video, we're going to be having a look at the 4 special situations in which the objective duty of care test is used, and then we'll end by making a few points on how negligence is proved in the realm of breach. Thank you for watching. I hope you enjoyed.